So welcome everyone to tonight's Publius Symposium. This is something that the Constitutional Law Center here at Stanford has been doing for about 6 years. Each year we choose what we think of as possibly one of the most important, significant new books in the field of constitutional law, broadly understood. And we invite the author to come and invite several other guests to respond to the book. This year, our choice is Jamal Greene's a wonderful new book, How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. Now, apparently, I don't need to tell you all the interest and importance of this. The number of advance registrations for this symposium was extraordinary, which is a real tribute to Jamal. But let me introduce him and our other speakers, and then I will get out of the way and let them go to it. If I might be, so Jamal is a professor at Columbia Law School. Professor of constitutional law. He also teaches comparative constitutionalism and various related courses of that sort. If I might mention a personal anecdote, this may embarrass Jamal, but I met him when he was a law student at Yale Law School, and I was there for some conference about one thing or another, and we happened to be thrown together at a lunch table. And I was so impressed with this young law student that I tried to persuade him to come clerk for me on the Court of Appeals. He said no, he had better fish to fry and went to clerk for Guido Calabresi instead. But ever since then, I followed his career. He has written multiple interesting, important articles in the Harvard Law Review and elsewhere. This is his first major book. And I'm not going to tell you about the book because he's going to do that. And then we have three respondents whom I welcome. First, Nadine Strassen, who is for just under 20 years the president of the ACLU. She was the first woman to be the president, the head of that premier and oldest American civil rights civil liberties organization. She's also the John Marshall Harlan Professor Emerita at New York Law School. And she has been a voice for freedom of speech and civil liberties in general for as long as I can remember. And we've been on numerous panels together. Her most recent book is on hate speech, and particularly proposing various ways in which hate speech can be countered without engaging in governmental censorship. So it's that's very much kind of in conversation with Jamal's book. Our next speaker is Judd Campbell, whom many of you will remember as the former executive director of the Constitutional Law Center here. So it makes me proud to see his career trajectory. He's a professor at University of Richmond Law School. And he has, his specialty has been the writing about the natural rights tradition in general and free speech in particular. He has a great article coming out in the Yale Law Journal on content discrimination under the First Amendment, the sort of the history and theory of how that idea for how to interpret the free speech clause has come into being. And so it's great to welcome you back, Judd, to Stanford. And then last but not least is our comparativist. We wouldn't want to have this topic without somebody from a similar but quite different constitutional tradition, namely our neighbors to the north, Jeff Sigalet, who has just accepted a position. Congratulations, Jeff, as a professor of law or assistant professor of law at the University of British Columbia, Okanagan. I envy him because it's such a beautiful part of the world there. In politics, but with us in government, I guess the department is called government, with a specialty in constitutional theory. And he has written about proportionality analysis and other topics which really deal with how other countries, including Canada, have addressed the very topics that Jamal's book is about. And so that promises, I think, to be a very fruitful part of the conversation this evening. With that, I ask you all to join me. If we were in person, I would lead a round of applause to welcome Jamal Greene as a featured speaker and honored guest at this most recent Publius Symposium.
Thank you, Michael, and thank you to Nadine and to Jeff and to Judd, and also thank you to Morgan Wayland and Chas Tyler for helping to put this all together. I'm very honored to be here and to speak with you, and I look forward to engaging on this topic. I'm going to spend a bit of time just kind of setting up the problem that the book is interested in, and diving a little bit into what I think is the right answer to that problem. But I'm going to spend more time just setting up the problem so that people are all on the same page as to what exactly I'm talking about. So this book, I think of it as a book about how both sort of legal decision makers and the American people should think about constitutional rights under conditions of radical pluralism. One of the questions that law professors like to ask about a legal dispute are what are the facts, right? That is, what are the legally relevant facts of a dispute, and specifically a dispute involving rights claims. And the case that I'm basically trying to advance is that we spend too much time thinking about what I'll call interpretive facts, the meaning of the text, the nature of the right that's at issue, and not enough time talking about what I'll call, just to be colloquial about it, what I'll call real world facts. What are the government's purposes? What is the relationship between those purposes and what the government is actually doing? What are the costs of the government's actions in rights terms? And what benefit is the government trying to seek? How far will the government's policies go towards achieving that end? And I'll give an example of just what I mean and why I think the way that we tend to think about this is a problem. And I'll use Citizens United, which is a case that I don't talk about very much in the book, but that should be familiar, at least in broad terms, to people in the audience, and certainly to my interlocutors. The interpretive facts of Citizens United are speak to questions like, what is a speech restriction? Do corporations have speech rights? If you want to get even more lawyerly about it, what tier of scrutiny do burdens on speech occupy? What tier of scrutiny should this kind of burden on speech occupy? Those were the kinds of questions that Justice Kennedy asks in his majority opinion in Citizens United. And the answers to those questions lead him more or less directly to his conclusion. This is a speech restriction. So in this case, it was a campaign finance restriction and expenditure restriction. This is a speech restriction. Strict scrutiny applies. So that's the most stringent form of constitutional analysis. And corporations do have speech rights, right? And so kind of QED, the burden on the government is going to be very, very high. And they weren't able to meet it for Justice Kennedy and the majority. Now, how would someone who was focused on what I'm calling colloquially real world facts have approached a case like Citizens United? Let's skip past questions about free speech rights, right? Free speech is implicated in Citizens United. We can concede that premise. That's not a particularly interesting question. What then are the real world facts? The facts those are the facts of the conflict between a litigant, Citizens United, and the government. On one side of this conflict is an ideological nonprofit, right? That's what Citizens United is. It's not just any old random corporation, which is trying to criticize a candidate in an election whom it views as hostile to its ideology, to its political objectives. So it makes a movie. That's important too, as I'll get into, a movie about the candidate. And rather than putting that movie in theaters, it distributes it on video on demand in the weeks leading up to an election in which that person, Hillary Clinton in this case, is a candidate. That's one side of the conflict. On the other side of the conflict, you've got a federal statute. The government believes that corporations are abusing the corporate form to dominate electioneering. The assertion is that drowns out the voices of individual citizens who are actually voters, right? So it passes a law, that law that says, the law doesn't say corporations can never speak under any circumstances. The law says that corporations that want to engage in certain kinds of electioneering, but not others, within 30 days of a primary election or 60 days of a general election, may do so, right? But if they want to do so, they have to do it through a separate political action committee that segregates their political funds from the general treasury funds of the corporation so that the corporation is not leveraging the corporate form in quite the same way in order to spend money on elections. Now, viewed through the lens of those real world facts, Citizens United is not an abstract, stylized dispute, right, between a government that wants to restrict speech and a set of citizens who want to exercise speech, right? The dispute is between a government that is trying to or asserting that it's protecting the political rights of its citizens through a quite specific law, and a corporate citizen whose directors think that the law goes too far toward interfering with their own free expression. Citizens United is a dispute between parties. That's what the dispute is about, right? The relevant questions through that frame then become, well, is it true that the government is trying through this law to protect the political rights of its citizens? Is it legitimate for the government to protect the political rights of its citizens? Does this law go too far toward interfering with the free expression of this litigant? In answering those kinds of questions, the facts, I'll put that in quotes, the facts that we might care about are not facts about what does free speech mean, right? The facts that we care about are what's the evidence that ordinary citizens are unable to participate meaningfully in the political process under the status quo, right? That's basically not discussed in Citizens United. We might care about what burden is associated with a corporation having to rely on a political action committee rather than its general treasury funds. Remarkably, that also was not discussed at all in Citizens United. We might care about the difference in audience capture between television ads, which were the main anticipated target of the campaign finance law at issue in Citizens United, versus video on demand, which is what Citizens United was using, right? You're not a captive audience if you're ordering a movie through video on demand. And so we might think about that differently than we think about commercial television ads. Not discussed in Citizens United. We might care about the difference between the speech interests and the benefits derived from the corporate form of a closely held corporation versus one that is, for example, publicly traded on a stock exchange. Not discussed. We might care about the difference between an ideological corporation like Citizens United versus a corporation that sells things like General Motors. Basically not discussed in Citizens United. These issues are not discussed because the way Americans and the way the court thinks about rights has encouraged us to think that rights conflicts are about those rather abstract legal interpretive questions like, is money speech, as opposed to being about real world facts. And at the heart of that tendency is what I refer to in the book as Rights-Ism. Rights-Ism is a disposition to view a rights conflict as a question of what the right is and whom the right protects. That's Rights-Ism. Rights-Ism is when we see a rights conflict, what is the right, who does the right protect? The alternative to Rights-Ism is to view a rights conflict as a dispute with important values sitting potentially on both sides of the conflict that require no abstract discrimination between rights. Right? A rightsist views a rights conflict as an opportunity to declare what rights the Constitution protects and what rights it does not protect. Rejecting Rights-Ism means instead viewing rights conflicts as the natural outgrowth of pluralism, as a legitimate conflict of values, and as a conflict is in need of mediation, not choosing who has rights and who doesn't, but mediating between the important rights on both sides of a dispute. There's nothing inherent in the nature of rights conflicts or in the nature of rights conflicts that are submitted to judges that requires judges to resolve them through Rights-Ism. And in fact, I think the proportionality frameworks adopted in many other countries that Michael referred to earlier do a better job of avoiding Rights-Ism than the frame that Americans tend to use. So let me say a little bit about how I think we got to this place. And then I'll say what I think, why I think it's a problem that this is where we find ourselves. We sometimes associate what I've called Rights-Ism with the founders. Right? We tell something like the following story. The Bill of Rights, or we can even go back to the Declaration of Independence and the unalienable rights to life, liberty, and the pursuit of happiness, right? Direct Declaration of Independence and the Bill of Rights set out a code of rights that are particularly in need of protection. When we get a rights dispute, the job of the legal decision maker is to figure out which of those rights is engaged, right? Which of those rights that are laid out in the Constitution is engaged in the dispute. Once engaged, those rights are protected robustly, right? They're listed there in the Constitution because they're meant to be taken out of the political process. Any kind of balancing, right, that reintroduces majoritarian politics or reintroduces general welfare in some way, that defeats the purpose of rights, because the purpose of rights is to take them out of the political conversation. Now, for the moment, I'll just say that this may or may not be an attractive vision of rights adjudication. I think it's not, right? And as I'll get to in a bit. But in any event, it's wrong to associate this vision of rights adjudication with the founders, right? The founders believed very strongly in rights, but they did not believe very strongly in judicially enforced individual rights that were absolute or anything close to absolute. Instead, what the Bill of Rights tries to protect are the localized political institutions that are needed to work out what people's rights would be. What was to be guarded zealously against federal interference was the right to live in a self-governing community. That community, acting through its local legislatures and councils, acting through its juries, which is central to the Bill of Rights, acting through its parish churches, acting through its family units, acting through local militia, those community institutions would determine the metes and bounds of individual rights. Indeed, they were relied upon to protect those rights from outsiders, and those outsiders included federal judges, right? So embedded within the Bill of Rights is a social, primarily majoritarian understanding of rights, not the liberal, quasi-libertarian vision, version that Americans, I think, too reflexively ascribe to the founders today. Now, there are lots of problems with this way of thinking about rights in the 18th and 19th centuries. Most importantly, most prominently, those self-governing communities that are at the heart of the Bill of Rights were exclusive communities. They gave political power only to white men. And this obviously won't do when we're talking about rights in a pluralistic society, right? Many of the people whose rights were in need of protection were not empowered to participate in self-government. So oversimplifying a bit, the Reconstruction Amendments that came after the Civil War were meant as a solution to this problem, right? In the recognition that even local governments cannot be trusted with the rights of minorities and the rights of political outsiders. So the Reconstruction Amendments empower judges and empower the federal government to protect the rights of these people. And it directly forbid excluding at least some of them from local politics, at least some of those people from local politics. Now, of course, the rights that end up being protected under the 14th Amendment in the first 70 years or so after that, or first 100 years really after that amendment was passed, were not the rights of minorities. And they continued to be excluded from local politics through Jim Crow and other forms of terrorism. And instead, the majestic language of the 14th Amendment ends up succumbing to the demands of powerful economic actors at the height of the Industrial Revolution. That language in the 14th Amendment is repurposed away from racial exclusion to protect the right to pay poverty wages, to resist unionization and collective bargaining, to stymie health and safety measures for workers and for consumers. And the New Deal settlement, as we call it, the change in constitutional law that comes after the New Deal, and what all constitutional lawyers will understand is footnote 4 of Caroline Products. This is a famous footnote from a 1938 decision that are attempting to recover something closer to the animating political moral vision of the 14th Amendment, while at the same time vindicating the progressive era social welfare project. You defer to legislatures, and again, just to take a step back to where I am, this is kind of the 20th century consensus, middle of the 20th century consensus. You defer to legislatures, which can be trusted with the political judgment to pursue economic and social welfare policy, but you don't defer when legislatures are violating specific constitutional prohibitions, when they're uniquely undeserving of trust, such as when they're engaged in political self-dealing, or when they're passing laws affecting so-called discrete and insular minorities. And so the paradigmatic violations of constitutional rights are the Jim Crow system, McCarthyism, other forms of overt political exclusion of one's ideological opponents. Judges step in to protect rights in those circumstances. They step in to protect rights in circumstances under which legislatures cannot be trusted. There's an intimate connection under the mid-20th century consensus between rights and distrust of government. Under footnote 4 of Caroline Products, those situations when we can't trust the legislature are to be determined categorically. Now that might work just fine, right? If the only rights conflicts that you're talking about are Jim Crow and McCarthyism, right? In those circumstances, aligning rights with distrust, right, makes a lot of sense, since the government actors in those circumstances in the Jim Crow South and through McCarthyism as just one example, those actors are in fact not worthy of trust. But that categorical Manichaean framework, right, becomes deeply problematic when we're talking about other kinds of rights conflicts. In fact, when we're talking about most kinds of rights conflicts. That becomes obvious when we look to the conflicts that arise in the 1960s and 1970s during an explosion of rights claiming. Sexual and reproductive freedom claims, gender equality claims, affirmative action claims, disparate impact claims, claims in the criminal procedure space, like claims to Miranda rights or claims to have a government lawyer be provided to you, or the right not to have exculpatory evidence concealed by the prosecution. Free speech claims on campus, free speech claims involving pornography or obscenity, free speech claims involving provocative activism like burning draft cards, free speech claims that interact with tort law, as in New York Times versus Sullivan and its libel standards. Government support for religious schools, government exemptions for religious believers, claims asking for more welfare benefits, or access to government benefits like tenure at a public school, or asking to make sure that your driver's license is not revoked or that your gas is not shut off by the local public utility, right? For all of those kinds of claims, which is it? Is it that we need to trust the government entirely, as in West Coast Hotel versus Parish, or the post, the New Deal settlement cases? We just social and economic rights, so we just doesn't matter what the rights claim is, we defer entirely to the government? Or is it that we can't trust the government at all, as in Jim Crow or McCarthyism? It's of course neither of those things. And yet we've persisted with a categorical framework that tries to fit claims into these binaries. And both sides do it. Right? Conservatives have resorted to originalism or other what used to be called interpretivist arguments as a strategy for getting at the true constitutional rights, right? So that they can exclude rights to abortion or rights to same-sex marriage, and can include rights to commercial speech or rights to guns or lately rights to religious freedom. And progressives resort to a variety of theories as a way of getting at the true constitutional rights that they believe are in the Constitution, so that they can include the ones that the conservatives want to exclude and can exclude the ones the conservatives want to include. And so in this sense, everyone's a little bit rightsist. So we want to discriminate between what rights are there and what rights aren't there. And so in this way, constitutional rights polarization, which we all see and experience, aligns with political polarization, and indeed over many of the very same issues. But it does so only indirectly because it tries to translate that political debate into a debate over what the framers really thought, or over whether strict scrutiny or intermediate scrutiny apply to a situation. Lawyers like me, right, then come to believe that those abstract legalistic questions are what rights conflicts are really about, right? That those abstract legalistic questions get at the legally relevant facts of a rights dispute. This way of thinking leads, I think, to at least three serious problems, and I'm just going to lay them out, and then I'm going to let my interlocutors challenge me in various ways. So the first of those problems that this kind of framing leads to is that it decouples the essential link between rights and justice, right? So in a disparate impact case, right, instead of asking about real world facts, like what is the government trying to accomplish? What's the magnitude of the disparate impact? What alternatives were available? Right, all of those kinds of questions speak to the justice of the government's actions. We instead ask, is disparate impact the same thing as intentional discrimination? Concluding that it's not, we say the Constitution must have nothing to say about it, right? Or in a case about school funding equity, right? Instead of asking, why does this inequity exist? What is it trying to achieve? What is its magnitude? Can it be reduced consistent with the government's objectives? Right? Real world questions about justice. We instead ask, is there a right to equal public schools? And concluding, as Justice Powell does in San Antonio Independent School District versus Rodriguez, that any such right would mean there also must be a right to food or a right to equal police funding. The court says there must not be such a right. We look at legal categories instead of looking at real world facts, and that distorts the relationship between rights and the justice that the rights are meant to promote. Second problem. The rightsist way of thinking prevents us from acknowledging that genuine rights conflicts can coexist and therefore need to be resolved, what I like to say, at retail rather than at wholesale. And we see that most clearly, I think, a lot of places one sees it, but we see it clearly in the abortion area, where in Roe versus Wade, Justice Blackmun concludes without analysis, right, that recognizing fetal rights has to mean that abortion restrictions are always permitted. Right? The Roe court's failure to recognize that fetal rights were at issue and that indeed the government's effort to protect them through law has constitutional dimensions to it, right, had an immediate impact on the anti-abortion movement in particular. In fact, it splits it in two, with the more radical camp vanquishing the moderates within a couple of years of Roe being decided. And that split, which the moral majority eventually takes advantage of politically, made political compromise around abortion rights nearly impossible, even though intense moral conflicts, like over abortion, are exactly what politics, rather than adjudication, is meant to resolve. Problem number three, and it's a related problem to the last one I just discussed. The kind of categorical binary frame that we tend to use means that every dispute is about whether you're in the category of rights holder or the category of non-rights holder. Are you living in heightened scrutiny land or are you living in rational basis land, right? Some of you who have studied this stuff, right, might recall Justice Powell's opinion in University of California Davis versus Bakke. This is the famous affirmative action case from 1978, where in his famous single authored opinion, he laments that if the dissenters in that case were to win, and the dissenters were urging that something other than strict scrutiny should apply in the case. He said, if the dissenters were to win, then the only people who are living in rational basis land would be white Anglo-Saxon Protestants. And everyone else would get to live in heightened scrutiny land, right? He says that creates a social conflict. But what he was doing is he was modeling the fact that Rights-Ism leads to rights envy and raises the stakes of constitutional conflict. So in the pandemic that we're hopefully on our way out of, right, it's about whether there's a right to hold a religious service or to not wear a mask on the one hand, or a right to public health, right, on the other. And only one camp gets to win. So name your favorite constitutional conflict, whether it's voting rights or masterpiece cake shop-like issues or affirmative action or a wide variety of speech-related conflicts, and similar dynamics appear. Our constitutional rights arguments recreate our political arguments, but they do so while claiming legal interpretive certainty and studiously avoiding the language of deliberation, of negotiation, of mediation that characterizes politics in its ideal form. This then means that when political actors discuss those same disputes, recognizing that they implicate rights leads to deference to judges and to the zero-sum legalisms that judges like to celebrate. Why negotiate toward a politically mediated solution if it's going to go to court anyway and get resolved in a zero-sum way that's going to align with the judge's political tribe, right? You might as well just put your foot on the political gas, maximize what you'll get out of a judicial win. I'm going to more or less stop there, and it will come as no surprise to you that I don't think this is a healthy way to go about resolving constitutional rights disputes. The thought I'm going to leave you with before I go into questions is this. The reason our constitutional rights disputes align with our political disputes is not because judges are activists, right? That's in some ways what judges want you to believe. It's because rights disputes are indisputably political. We could decide to remove judges from them entirely. I think that's a bad idea, both on the merits, and I also think it's too late in our political life to do that. That's one option, and it's a bad option. Or we can continue to be rightsist, which has the destructive consequences that I've laid out. Or we can try to seek a third way, one that focuses on real-world facts, one that continues to empower judges. They're still a part of the story, but in a way that seeks to promote mutual respect and to restore some degree of constitutional responsibility to the political process, which is where it ultimately belongs. So I'll pause there for comments.
Well, thank you so much. That was a wonderful presentation, Jamal. It was pre-agreed that I would be the first commenter. So I want to start by adding my thanks to those that have already been expressed by Michael and Jamal, to everybody who's participating, everybody who organized this. Jamal, I really enjoyed your book. As you know, I was honored to blurb it on the cover, and I was really happy to reread it for purposes of preparing for this event. In addition, I appreciated what you added in your oral presentation just now, especially the commentary about the Citizens United case. It is a point that I try to make every time I talk about that extremely unpopular but extremely misunderstood decision. Likewise with other so-called campaign finance reform decisions, all of which the ACLU supported, and in a number of which we were actually parties, because guess what? Like a lot of other not-for-profit organizations, we are organized in corporate form, and our speech, which by our own corporate charter can never advocate for or against the election of any official that would be completely antithetical to our organizational mission. But the law that was struck down in Citizens United made it a crime for the ACLU during the crucial period when people are paying attention to issues, the period in a run up to a campaign. It was a crime for us to spend our hard-raised money to advocate on civil liberties issues if we merely mentioned the name of somebody who was running for office. So we could not do what we otherwise would have done when George W. Bush was running for re-election, saying, President Bush, please allow the rights violating provisions of the overreaching Patriot Act to sunset. That became a serious crime. And when I would explain this I remember explaining it to my husband, and he said, I don't think people understand that that's what the law does. The ACLU ought to bring, and we went through that, the court said, well, maybe there can be an as-applied challenge in the future. And I explained to my husband that if we did bring such a challenge, I could face 5 years in prison as then the president of the organization. And I said, would that be a price worth paying for these free speech principles? And he said, yes. So I had to smile as I heard your, getting to the facts really does get people beyond the abstractions where they already know which camp they're in. And they're often surprised to hear about the actual impact of a law that they believe that they hate. So thank you for that wonderful explanation. Jamal, your ears should have been ringing yesterday because I had the honor of being interviewed by our mutual colleague and friend to all of us here, Professor Akhil Amara at Yale Law School, who has a fairly new podcast called America's Constitution. And he had asked me a question about abortion, in which I quoted your book because it well summarizes a lot of my own attitudes about this issue. I'm constantly seeking avenues to discuss and explore common ground that I firmly believe should unite those of us who are pro-choice and those of us who are pro-life. And by the way, I would hope all of us are pro-choice and pro-life, but it's been getting increasingly difficult to be able to find even opportunities to have that kind of discussion because each so-called camp only wants to talk about what they disagree with, and somehow you're a traitor if you're even trying to talk about common ground. So in that context, I tried to paraphrase what you talk about and how it came out very differently in Germany. And he immediately, very proudly bragged that you were his student. So your ears should have been ringing, as I said. Now that abortion example is a really important example of one of the many points in this book that I completely endorse, both general points and specific points. And I certainly agree with you that the binary approach, the Manichaean approach, is not a healthy one, especially because we have so many situations where there are two rights at stake that even the Supreme Court, in its binary approach, has recognized both of them as fundamental. For example, free speech and privacy are often in tension in many different factual situations. And in those situations, the court is forced to do a very fact-specific weighing, right? Which I assume is consistent with the analysis that you would propose. There's no alternative. In fact, even more poignantly, when you think about it, those cases involve conflicts between one set of free speech concerns, namely access to information and transparency on the one hand, versus another set of free speech concerns, namely not to be deterred or chilled from engaging in expression when you realize that you will be subject to disclosure. And in fact, the Supreme Court had to wrestle with these issues just Monday, a couple of days ago, in a case that was argued by Kathleen Sullivan, former dean of the Stanford Law School. For now, in the limited opening comments, I would like to give one more example of an important general point where I agree with you, your book and your analysis, and one general point of disagreement, or more accurately, of questioning. So the other general point of agreement is the danger of ceding such special power to courts in particular to determine these important issues, and the danger to rights themselves, among other dangers. And that's because other branches of our government and other elements of our society become too anemic in assuming their essential responsibilities. And I know the learned members of this panel can, delve into theoretical and philosophical and jurisprudential reasons for concern here. And since I have experience as an activist, I would like to focus on my actual experience with this issue. So I'm going to cite a couple of examples. One goes to the Communications Decency Act, which Congress swept through with almost no dissenting votes on either side of the aisle in 1996 as its first and predictable reaction to the internet. Namely, it's going to, children are going to be exposed to sexual speech. We had a real sex panic going on in our country at that time. So that was, as is often throughout US history, the most feared, most demonized kind of speech. So Congress passed this law that would have made it a crime to post any so-called indecent or patently offensive expression online. Fortunately, and again, almost nobody in Congress voted against it. Among other things, the name Communications Decency Act. To our great surprise, the US Supreme Court unanimously struck down the law in Reno versus ACLU, Janet Reno being the Attorney General under Bill Clinton. So yes, the Clinton administration also supported this speech suppressive law, but the United States Supreme Court essentially unanimously overturned that law. And just like the day after the decision, I happened to be on Capitol Hill testifying on another issue. And I was really disheartened by the number of members of Congress who came up to me and thanked me, thanked the ACLU, congratulated us for having persuaded the court to strike down a law that they had voted for. And many of them expressly saying, we knew it was unconstitutional, we knew it was unworkable, we knew it would do more harm than good, but we didn't dare vote against it. So thank you for doing the dirty work that had to be done, making those arguments and persuading the court. The other example I want to give involves another federal statute, which those of us who know it lovingly refer to by the acronym RFRA, the Religious Freedom Restoration Act. And to give a little bit of a background, this arose from a Supreme Court decision in 1990 in which Justice Scalia authored the majority opinion. And basically he reduced the scope of the free exercise of religion clause under the First Amendment to applying only to laws that intentionally discriminate against or burden religion intentionally. And if a law imposes a substantial burden on religion, even a very substantial burden on religion, if that is done unintentionally, as an incidental byproduct of a law that's written in neutral general terms, you don't even have a First Amendment free exercise claim. Now, I realize you may support Scalia's approach, Jamal, from something that I read in your book made me think that you might support the idea that that Scalia cited, that people should not be able to use their claims of individual rights, including religious freedom, to seek exemptions from generally applicable laws. Michael, of course, has written very forcefully and eloquently to critique the Supreme Court decision. Congress reacted by passing this law, which stands for Religious Freedom Restoration Act, to literally try to restore the law to what it had been before that decision that shrunk the then accepted scope of the Free Exercise Clause. I testified in support of RFRA in both houses of Congress. Virtually every religious denomination under the sun testified in favor of it, as well as the civil liberties community. And then the Supreme Court struck it down in a case called the Bernie case in 1997. Basically saying that this had, basically, this is somewhat oversimplified, of course, but basically really expansively defining the court's ability to be the final arbiter of the scope of constitutional rights and limiting Congress's ability to try to expand the concept of rights. Critics at the time said that this was an even more expansive concept of judicial review and judicial supremacy than Marbury versus Madison. Congress called a hearing shortly after the Bernie decision about what can we do to protect rights after this decision. I was one of the people who testified, and another witness at that hearing was then a member of Congress from the very district where Michael and Morgan and others are, namely Tom Campbell, who had been a law professor at Stanford Law School. And he was a bit of a constitutional historian. And I will never forget that his testimony was explaining how Congress used to take rights very seriously and be so concerned about the concept of rights that the very first two recorded debates in Congress in both houses were precisely about that. And it's the exact opposite of a situation where Congress has eased out either because of its own political concerns, as in the CDA situation, or because of the courts telling Congress that it has to back out, as happened in the Bernie case. So now I could say more, but let me pass on to my general point of disagreement or questioning. And I say questioning because of another aspect of your book that I really applaud, Jamal, and that is that you avoid the very binary approach that you critique. In the conclusion of your book, you say the suggestions in this book are invitations, not manifestos, in the spirit of humility to which we should all aspire. I don't have all the answers to these challenges, and neither do judges. There's no shame in that. And I would say, amen, women. So in that same spirit, let me humbly make a suggestion about one of your suggestions, and that's in the chapter about free speech issues. You suggest that courts should review each case by narrowly focusing on its specific facts, including the perceived value of the particular speech or message in the case at hand, what the complaining party actually said. And while I agree that facts are very important, as I said, with respect to Citizens United, I'm a little bit concerned. So I suggest that there may be a danger of overlooking other speech that the government has censored or will censor when it enforces whatever rule it invoked to punish the particular speech. So, for example, you say we must stop pretending that letting a state keep hate symbols off its license plates threaten the republic. And of course, you're referring to the 2015 decision of Walker versus Sons of Confederate Veterans. But what I'm really concerned about is the power that the court upheld in that case could be used and was used not only to keep particular symbol of hate off, but to allow what other people perceived as symbols of hate to remain on, and also to suppress some speech that was not seen as hateful. So if you look at the actual enforcement record, and the same thing I would say about the University of Michigan and Wisconsin hate speech code cases that you talked about. For lack of time, I can't go into the examples. I'd be happy to mention them during the discussion period. But I think we're ignoring reality if we think we can focus just on the particular expression that happens to be before the court in a particular litigated case without worrying about the adverse implications. So I want to come to an end because I've definitely spoken more than I was supposed to. So to end on a positive note, I do enthusiastically agree with many other points in the free speech chapter, and I just want to quickly list two of them. First, that we professors have a critical responsibility to work with our students to selectively curate invited speakers so that they have some legitimate pedagogical purpose. I have independently made that point many times myself, so here. And second, that as educational institutions, universities should respond to hateful speech with educational approaches, not punitive ones. And again, you're making these suggestions not from a rights-based orientation, but from a much more sophisticated, complex, nuanced consideration of all of the factors consistent with the overall thrust of your excellent book. So thank you very much. And Judd, I think you're up next.
Great. Thanks so much, Nadine. And it's great to see so many people attend this. Appreciate the Constitutional Law Center hosting and Jamal for writing such a great book. I used to provide beer when I was out there. I thought that's what got people in the seats, but I see I'm proven wrong. I just have 4 brief comments. I want to have 2 that are very much supportive and 2 that are somewhat skeptical or questioning. The first comment is that I just love the framing of the book, thinking not just detailed, heavily contextual, heavily fact-based about particular contexts, but stepping back and thinking more generally about what rights are. And realizing that we have adopted a sort of essentialist conception of rights that doesn't map on necessarily to the way that Americans have always thought about them. I love that move, and I think it's really important. Just to raise an example, in Heller, the Second Amendment case, Scalia goes through the text of the Second Amendment, but he completely elides what a right is. And when he gets to Justice Breyer's dissent, which engages in a sort of proportionality analysis, he just offhandedly dismisses it as something that we don't do when we deal with rights. Presumably, Justice Breyer got this from visiting Europe too much or something. And so it's really helpful to be able to think more deeply about what rights are. In that vein, my second comment is I just wholeheartedly agree with Jamal about the founders. This is not the way the founders thought about most rights. Some rights have a hard and fast rule-like structure that requires the government to act in certain ways. But for the most part, Jamal's absolutely right that the way the founders are thinking about rights channels decision-making towards representative institutions that are able to adjudicate rights conflicts in ways that reflect the popular will. And that is seen to be the best way of promoting the common good. So I just love that as well about the book. My first point of skepticism is about the ability to reduce some of these problems to what we call their facts. So here I have a slightly different point, but relates to Nadine's comment. My concern, and particularly here for those who read the book, I'm thinking about Jamal's critiques of Justice Holmes's approach, which is much more of a hands-off, deferential approach to legislative judgments. Is that a lot of the debate is not about what the facts are, but instead is about value judgments that we make. What sort of ends is the legislature able to pursue? And Jamal definitely recognizes this at various parts of the book. Certainly the discussion of affirmative action is exactly about this. But I wonder about the degree to which we can sort of just think about, especially when analyzing legislation, what are the facts if really what goes to the legislation's validity is a question of value. So for instance, in the Lochner case, the debate is in the Harlan dissent largely about whether or not there is or isn't a health and safety concern with regulating baking hours, the working hours of people in bakeries. But one of the things that Holmes is picking up on is the idea that maybe the state's interest could just be simply of judgment that there's inadequate fairness in the labor negotiating process, that working more than 8 hours a day across the industry is deemed as not fair labor standards, and that either for the particular workers or for the industry as a whole produces the sort of economic harms that requires the government to step in. That's not something we can really assess in terms of the facts themselves. I mean, certainly setting the context helps, but at the end of the day, I think there needs to be some assessment of what the ends are. And there, I think one of our problems in modern rights jurisprudence is that if we say that rights are regulable in promotion of the public good, we need to have some account of what the public good is. And we've sort of lost that. Like, we've lost a sense that there is such a thing as the public good. Everything just kind of gets reduced to public choice theory, legislatures hammering out conflicts among competing interest groups and so on. And so I'm just not sure how to get around that problem, if that's the conception of what rights are, especially when we're dealing with challenges to legislation, figuring out how we assess what sort of values or normative judgments the legislature is allowed to pursue or make. And then the last comment that I have is also somewhat skeptical, but maybe not, depending on what Jamal says. And that is just jurisprudentially, what are you doing? Like, where are these rights coming from? And why is it that judges get to enforce them? So I have an account of that. My account is wholly historical. It's not normative. And that is that we have a social contract that underpins all of American constitutionalism up until the mid-20th century. The social contract recognizes natural rights that implicitly places limits on the government's authority. You don't cast the book as an effort to recover a tradition of social contractarian natural rights. And that seems like a good idea because people generally don't seem to believe in them anymore. I'm sort of agnostic on that issue. But I'm just wondering if that's not where we're getting these rights, where are they coming from? Is the jurisprudential move to say judges have a general duty to see that justice is done, or that the Constitution somehow instantiates a principle of justice, that this is all getting done through the recognition of liberty in the due process clause, something like that? So I'm kind of curious on those lines, where it is that judges, if they're not doing interpretation, get the warrant, the authority to intervene, especially in contravening legislative decisions. Thanks so much.
Great, I'll just hop in and follow up on Judd. I have two personal notes to make and two more substantive comments, all made from a more Canadian perspective. Not a more Canadian perspective, a Canadian perspective. Hello to everybody, bonsoir from Montreal. I have two personal things to say. The first personal thing is that I'm very grateful to Michael McConnell for bringing me here, or virtually bringing me here, and to Jamal for writing this book and writing his Harvard Law Review essay on this topic. And way back when I was writing a dissertation on rights theory and weak form constitutionalism in the Commonwealth, and Jamal came to Stanford, where I was already a fellow before I had finished my dissertation. And he proposed amending the US, there was a conference where the proposals were, how would you amend the US Constitution if you could? And up until that point, I've been writing about proportionality in Canada and what's called our limitations clause. So the Canadian Charter starts off with Section 1 saying, all the rights in this charter are subject to limitations that can be reasonably justified in a free and democratic society. And that's what the court, how our court, Supreme Court, says that then it can approach limits on rights, looking at whether or not the limit is proportional, whether or not the Parliament has proportionally limited the right. Well, Jamal came to Stanford and said his proposed amendment would be to subject the entire US Bill of Rights, I think it was the whole Constitution, to a section of the almost verbatim version of Section 1 of the Canadian Charter. So I was already in heaven thinking, oh my God, this is going to be so fun to talk about. And sure enough, it was. And I think that, that the conversations that we had based on that conference really have just been so fruitful for my career. So I'm really grateful to you for that. And to you for writing this book. The second personal thing I'll say is I really enjoyed this book. And I learned American constitutional law more from either drinking glasses of wine and talking to Michael and Judd about this stuff, or from reading it from a more theoretical perspective and not strictly through a case law way. And so I didn't get law professors telling me the stories behind every case as we went through cases. So I really enjoyed how this book talks about the background about Felix Frankfurter and his relationship to Justice Holmes and the almost love letters he wrote him. It's got lots of this book's not dry, not as dry as my comments will be about it. So now into the substantive stuff, and I want to get going quickly because I have a bit to say, and I want to leave room for the Q&A. My two substantive points are, first, that I think that there's a real empirical contribution to this book. And one of the empirical contributions of the book is that when we look at American rights jurisprudence and you ask, what exactly is going on in it? Is it more like the Canadian way of doing things? Are judges balancing rights as interests, or are they really doing some more strict categorical rights, two-track rights claims saying that you either have a right or you don't? Which one of those things are they doing? I think Jamal covers the jurisprudence in a way that both shows the historical development of American rights jurisprudence towards that on-off rights as trumps discriminatory concept of rights. And then he also shows how across all these different doctrines and areas, American rights jurisprudence is characterized by that on-off switch kind of style, generally speaking. And I think that it's important to underline that that's not necessarily something that that people knew about or could have agreed about or that was well known or well established before Jamal wrote this book and his rights as trumps forward to the Harvard Law Review. There's a professor at Oxford who's very brilliant and written really good stuff on rights jurisprudence in the States named Paul Yowell, who argued that American rights jurisprudence a lot of time actually looks like proportionality. And I think he has a point. I think in lots of cases it actually does involve something like balancing rights, or some aspects of American rights doctrine do have this kind of more Canadian balancing style of approach. But what Jamal shows is that across these doctrines, overall, it really is more of an off and on again, a two-track concept. You either have a right or you don't. And courts put a premium in the States across the different tiers of scrutiny on whether or not there's a rights claim at issue. And in deciding whether or not there's a rights claim at issue, they'll put you in a different box of scrutiny. They'll either say that this gets rational basis, so the government will probably get away with it, or they say that it's sort of in the middle, intermediate scrutiny, so the government might get away with it, or they'll say there's strict scrutiny, there's a really important right at stake here, a fundamental right, so the government's unlikely to get away with it because it needs a really compelling reason to get away with it. Now, I think that he's right, partly because after I read his Harvard Law Review, I decided, oh my gosh, I need to try to show he's right in a more empirical manner. So I coded every American, with the help of a research assistant who's actually going to go to Columbia Law next year named Neelish Thacker. So I hope that you can see him in one of your classes at some point. And what we did was we coded every American rights case between 1982 and 2018, and we looked for whether or not what the American court was doing in these federal rights cases looked more like the Canadian court, whether or not across the different tiers of scrutiny, the American Supreme Court was willing to say, was willing to countenance the justification of a rights infringement, whether or not they said this law infringes the right. Does the government have a rational reason for doing that? Or does it have a compelling reason for doing that? Or does it have something in the middle? Is it narrowly tailored to that? What we found was that Jamal's right, that the lion's share of American cases don't look like the Canadian example. They look like a more on-off again. Is there a rights question at stake here, or is there not? So we found that 36% of American cases look more like the Canadian approach, and that proves Jamal largely right empirically, even though you can already tell that from his really in-depth analysis of his book that there's a lot to his arguments. So that's my first substantive point, just to say that this is a really interesting book in terms of introducing you to this wide swathe of how American courts think about rights across all these different doctrines and how it develops historically. So it's a very compelling book on that first substantive way. My second point is more critical, and my second point is that the overall normative thrust of the book appears to be that Jamal thinks that if American courts are more willing to think of rights as interests and more willing to talk then about whether or not the government might have a good reason for violating a right, and to orient its discussions about rights along those lines, like the Canadian court tends to do under that idea of establishing whether or not rights under the Charter are justifiably demonstrably just, the limits are demonstrably justified in a free society. If the idea seems to be that if American courts follow the Canadian court's cue that way, that legislatures and the political branches will be more likely to involve themselves in the messy parts of these rights questions, that they'll be more willing to engage. And so along those lines, I think if Jamal's right about that, then you'd expect Canadian legislatures to, first of all, often get their way about different kinds of rights questions. You'd expect the Canadian Supreme Court, the Canadian lower courts to often say, look, there's a lot of complicated interests at stake in this rights question. We don't want to be too absolutist about rights, so Parliament should get its way. And empirically, what's fascinating is that as proportionality became more prominent in Canadian law, the Canadian court actually started becoming more activist and more likely to strike down laws. So again, my handy research assistant have coded all the Canadian cases between 1982 and 2018, and we found that the lion's share of cases that strike down laws involve a really strict form of proportionality analysis, and the court's less likely to uphold a law if it actually employs proportionality analysis under Section 1. So that's interesting in and of itself. It sort of gives us reason to pause in thinking that proportionality analysis might actually result in more deference to the political branches as they engage in rights questions. And the second part of that's interesting empirically is that another thing you might expect is for Canadian legislatures to reply more, let's say, to engage in what the Canadian Supreme Court has called dialogue with the Supreme Court about the limits on rights. And the idea there might be that if rights are treated like interests that are balanceable against one another, that there may be more room then for the court for Parliament to reply to a judicial decision where the court balances rights with a new policy trying to reassert another interest at stake, or to contradict the court about what it said about how rights are balanced in a specific issue. And what is empirically really fascinating to me is that when we tracked whether or not there were responses to judicial decisions that disagreed with where the Parliament or Congress disagreed with the Supreme Courts in their respective countries, American courts were actually slightly more likely to respond to Congress than the Canadian Parliament was to respond to the Supreme Court. And one reason that's really, to me, was unexpected is that it's much easier overall for the Canadian Parliament to pass a law. It's easier to get a law enacted under the Parliament because we don't have a separate president who can veto the law. The executive is fused in Walter Badgett's language. It's the Prime Minister sits within the House of Commons. We don't have a upper house that really has a robust ability to frustrate the lower house.
the Canadian Senate formally is pretty powerful, but informally it's expected absolutely that it cannot fully obstruct laws enacted by the democratically elected House of Commons. By contrast, the American Congress and the American version of the separation of powers makes it much harder for there to be enactments. And so it's really surprising that we find that in the context where there's proportionality analysis, there isn't more likelihood of Parliament responding to judicial decisions about rights. And I think that this is really exemplified in the case of abortion law in Canada. So when Jamal talks about abortion law, he's keen to compare the American and German experiences. And in Germany, in America, the Supreme Court in Roe doesn't recognize the right of a fetus to life, but it recognizes the right to abortion under certain circumstances that then change as the jurisprudence develops, right? In Germany, the Supreme Court, the German Constitutional Court, I think it's the Bundesverfassungsgericht, recognizes both, I'm terrible German accent, but I'm trying. We speak French, not German. So the German court recognizes the right of a fetus and the right of a woman. And in Jamal's view, that makes the rights disagreement much more reasonable. Well, the Canadian court took the German approach, the proportionality analysis, and on a very narrow plurality, struck down a law that actually made abortion available, but just put severe procedural restrictions on it. And they struck down that law in its entirety. And the Canadian Parliament featured several bills trying to respond to that were all shot down, either in the upper house or the lower house, by the pro-life and pro-choice factions of the liberal and conservative parties, to the point where, and abortion after that became a subject on which the polarization about the issue totally inhibited the ability of, and more importantly, the incentives for any political actors to do anything about it, to the point where there is no Canadian law at all about abortion till this day. It is completely unregulated. A doctor could kill a baby before it was born, and nothing would happen. It would be perfectly legal. And in any case, I'm not trying to make this point as a matter of making a substantive pro-life case for it. My point about bringing up abortion is that in this case, you had a proportionality analysis, German-style approach to the rights question by the court that still interfered with the democratic enactment relating to this dispute, and appeared to be just as inhibiting, if not more inhibiting, about in terms of involving the legislature in settling this dispute. And my point is that this is all just to make the point that it seems to me that the Canadian example, my humble country to the north, may pose some issues or maybe offer some reasons for skepticism or perhaps revising aspects of the theory offered in Jamal's work. And that being said, though, as I said, starting off my comments, I really enjoyed the book, and it's just so fun to argue and think about it. And I look forward to you continuing to make these kinds of arguments in the future. And that's it.
Thank you, and thank you to all three of you. I'll be very brief in trying to say a few things in response, and I'll generally just say thank you for the supportive words, and I'll just say a little bit about the more critical aspects, just because that's more interesting. So just to Nadine's point. So first thing I'll say about Nadine's points is just on Citizens United. To the degree we think of that case as just a case about corporate political speech on one side or political equality of citizens on the other side, as I was saying, that recreates and reproduces the political debate around campaign finance in ways that prevent people like me, I'm left to center, from agreeing with. So like if you say, if the only question in Citizens United is, can corporations speak as people can speak in all contexts relating to elections, I'm going to say no. I disagree with that. But if the question is, can Citizens United speak? That's a much more interesting question to me. And I think there are lots of good reasons why Citizens United should be able to speak in exactly the way it tried to in that case. Just so quickly on RFRA and Smith, I wholeheartedly disagree with employment division versus Smith. I don't like that case one bit. I'm also not a fan of RFRA being interpreted as a robust version of strict scrutiny. I don't. I think RFRA is closer to what we should be doing than Smith is. And just on how contextual one can be in free speech cases, I'll just very quickly just say I'm not for, in all for free speech cases, the court sort of deciding whether allowing the government to say, we like this speech or we don't like this speech, or some speech is better than other speech, but to say that there are circumstances in which what the government's doing, whether it's issuing license plates, whether it's a university, is as relevant to the case as whether speech is at issue. And so the question becomes, is what they're doing germane to the institutional purpose? And I think that about universities, and if we're talking about anti-harassment codes and they've got students on campus, that really matters to a university's mission, is the comfort of their students, in ways that it may not matter and doesn't matter to police officers, for example. And as to license plates, I think the Confederate flag is a very particular kind of symbol to put on a state license plate of a state that was once in the Confederacy, right? And so that matters in ways that other forms of discrimination may not be nearly as germane to the purposes behind putting out license plates. To Judd, I think a couple of challenges. One is, are there cases where it's just a dispute about values, right? So Lochner, maybe in one view, Lochner's about labor, about whether particular kinds of health and safety measures are justified, and maybe that can be resolved by reference to certain kinds of social facts. But if it's just about, how much can you protect labor or not, and is that a legitimate governmental purpose? That's a question of value. I think that's right. So I don't think all questions can be just reduced to their facts. I do think that the kind of jurisprudence we should be developing is one that treats that question, what kinds of ends is the government allowed to pursue within our tradition, as being just as important to the jurisprudence as, is there a right to contract, right? So it's to say we should develop a common law that tracks the questions that are important to particular kinds of cases. On the second point, where does judicial power come from if you're not doing interpretation? So I don't think judges shouldn't do interpretation. I just think that in a lot of the things we disagree about, that interpretation is completely underspecifies what we can say about a case. So I think judges should be doing interpretation, and judicial power I would justify in much the way that Marshall does in Marbury, which is to say they've got a dispute that's in front of them. Their power doesn't come from a power of, some independent power of judicial review that comes from the Constitution. Their power comes from the fact that they have a dispute in front of them and they have to apply the law to that dispute. And the law includes the Constitution, and the Constitution has to be interpreted. I agree with that. But again, I think it only goes so far. And resolving the dispute, which is what they're really supposed to be doing, requires asking a set of questions that go well beyond interpretive questions. And to Jeff, whose work is just awesome in this space, and the amount of work he's done in this space is very inspiring, and I encourage all of you to read his work. The two points that I'll just make. One is, does Parliament doesn't seem to get its way as much. And Jeff says we should expect that to happen. I'm not sure we should expect that to happen. I think how much a court defers to the legislature is tangential to, orthogonal to, the question of whether they're using proportionality analysis or something more categorical. I think one of the things the US approach to rights does is it actually ends up insulating a bunch of would-be rights from review, because the court stays away from certain kinds of putative rights because they think they have to protect them absolutely. That's why we don't have disparate impact analysis, for example, both in race and religion. And so, you know, so in that sense, right, there are certain kinds of rights that the Canadian court's going to deal with that just never get dealt with in the US context. Is there more dialogue? I think, you know, this. I look forward to reading the paper. I think that if I were persuaded that a particular approach disempowers the political process for no good reason, then I think that's a good reason to push back on it, right? So and so the point of the book is not to say, you know, pick out the jurisdictions that do proportionality, and those are the good jurisdictions, and the ones that don't are the bad ones. It's to say that the kinds of questions we should be asking are the kinds of questions that are asked in these jurisdictions. I do think that that has certain benefits in terms of political conversation, but if it doesn't have those benefits, then that's a reason to think differently, right? So I'm totally open to empirical demonstration that I'd want to look at it, right? But I'm totally open to empirical demonstration that what I'm saying doesn't necessarily lead to the consequences I claim for it, and also that you know, sometimes courts get things wrong, even if they're applying the right form of analysis, right? So so that's obviously a possibility. Thank you.
Thanks, everyone. Since we're very close to the end of our time together, I want to make sure that I get in one question that's come up at least 3 different times from our folks in our audience. And those questions really go for you, Jamal, but if other folks want to weigh in, that's great too. Really focusing on the methodological consequences of your proposal. So as I'm sure you've thought about, what happens to precedent with the approach that you provide? Are judicial opinions now less widely applicable because of the elevation of facts in order to reach decisions? What does that mean for precedents that, you know, longstanding precedents that we have? What does that mean for the development of the law going forward? How would you address that? And I should say, we certainly don't want to fetishize precedent as, you know, we don't have to go about thinking about developing the law using precedent. There are other ways to think about it, but it certainly, your approach certainly would have an effect on the role of precedent.
Well, yes and no. I mean, so I believe in precedent. I think precedent is important, and I think there are circumstances. I think there's lots of uncertainty within American law. I think there are lots of things that precedent doesn't resolve very easily, and as Jeff alluded to, there are lots of ways in which U.S. courts do some version of a kind of proportionality analysis, or work their way to the kinds of outcomes they would reach if they applied a proportionality analysis. They just justify it in different ways. And so I think cleaning up what courts do methodologically is I think methodological precedents are less powerful than substantive precedents, and I'm not even, you know, since what I'm suggesting, I think would provide more coherence and clarity to the law. I think that's a value, that the same kind of value that is promoted by precedent. So I'd have to think about it in particular cases, but and this is a sort of broader point about the project. The project is not to say here's what the law looks like. Here are a bunch of outcomes the court has reached, and I don't like them, so I'm going to propose a way to get to some other set of outcomes. You might very well reach similar outcomes, but I think, and this is subject to dispute, right? But I think that how courts talk about rights disputes matters to how the rest of us talk about rights disputes as well. I think there's a lot of ways in which that's demonstrable over history, and so I want courts to be engaged in a different kind of conversation than they're currently engaged in, because I think that we all have to have a stake in resolving rights conflicts. We can't view them in these legalistic terms. They don't deserve to be viewed in those terms, and it's destructive to view them in those terms.
Michael, do we have time for one more question, or are we out of time, do you think?
Let's have one more.
Okay, great. So perhaps Nadine's story about Congress and the CDA might sort of dovetail into this question nicely, but at least one of our audience members was sort of, I guess, worried about the competence of different branches when it comes to making public policy decisions, and wonders if the real problem is that no one really wants serious public policy choices to be made by legislatures, but would rather have them made by judges who are insulated and have independence without having to worry about facing voters.
So I think it's true that one of the functions that courts play within our society is to take certain kinds of political questions that politicians themselves, as Nadine suggested, don't want to handle or don't want to deal with the political consequences. So I think that is one of the functions. I think that that's a bad function in a democratic society. And I should say, and this is important, that when I talk about politics, and I talk about returning certain kinds of questions to political conversation, I don't necessarily mean legislative or electoral politics in all cases. I mean revitalizing a political culture, right? We're engaged in politics right now in this conversation because politics is a process of resolving disputes in peaceful ways. Rights conflicts are about dispute resolution. And part of the point of the book is that the way in which a democratic society resolves disputes is by reference to the kinds of questions that proportionality analysis encourages, and that resolving those disputes by reference to abstract legalisms is to de-emphasize exactly the politics that we need to resolve them in constructive ways.
So thank you very much, Jamal, Nadine, Judd, Jeff. It went by very fast. It was a wonderful hour and a half. I'd be happy to go on farther, but I'm guessing our audience may have things more important like dinner to be looking forward to.
Bedtime on the East Coast.
But thank you very much. And again, the book we've been talking about is Jamal Greene's. Actually, you can't, it's all sort of backwards. Here we go. How Rights Went Wrong. Mine is reversed. How Rights Went Wrong. And so I do really recommend it for a good read, whether you agree with it or not. And thank you, Jamal, for taking the time to be with us this evening. Our next event for the Constitutional Law Center is next week. Which night is it that Bernie Mylar is speaking, Morgan?
We have so many events, Michael. We have a few before Bernie's talk.
Oh.
So next week, in fact, we have an event during the lunch hour at 12:45 that we're co-sponsoring with the Center for Law and History, where Jack Rakov, who is featured on the back flap of this wonderful book, will be talking about his new book, Beyond Belief, Beyond Conscience, the Radical Significance of the Free Exercise of Religion. So we hope you can join us 12:45 on Tuesday. So
thank you. And again, thanks to the speakers, and please, audience, join me in thanking Jamal especially for that excellent presentation.
Thank you to everyone.